What is a contract? In this module, we explore the basics of contract law, emphasizing the elements that make contracts enforceable and the role they play in architectural practice. Contracts form the foundation of relationships between parties in construction projects, ensuring clear expectations and accountability. This module will guide you through understanding contract formation, contract administration, and the specific responsibilities of architects within these agreements. Learning objectives. Upon completing this module, you will be able to understand the essential elements needed to form an enforceable contract. Distinguish between express and implied terms within contracts. Recognize circumstances under which termination, repudiation, or damages may arise. Determine when it is necessary to seek legal advice for contractual issues. What is a contract? A contract is essentially a legally binding promise or set of promises made between two or more parties. It is an agreement that outlines each party's obligations, with the expectation that these obligations will be fulfilled. Contract law ensures consistency and certainty in business dealings, compelling parties to either meet their promises or face compensation for failing to do so. In the architectural context, contracts are not only about the obligations of the parties involved, but also play a crucial role in defining the architect's role in administering the contract and maintaining project integrity. Elements of a contract. To be legally binding, a contract must include the following key elements. Offer, a party's clear proposal to enter into an agreement under specified terms. Acceptance, unconditional agreement to all terms of the offer. Consideration, something of value exchanged by both parties, such as money, goods, or services. Intention to create legal relations, the intention of both parties to be legally bound by their agreement. Certainty of terms, the terms of the contract must be sufficiently clear to be enforceable. Sources of contract law. Contract law stems from two main sources. Statute law, law enacted by Parliament such as acts and regulations. These provide a legal framework within which contracts must operate. Common law, judge-made law, which evolves through court decisions. Much of contract law is derived from these judicial precedents, which help interpret the obligations and rights of contracting parties. Express and implied terms. Express terms, terms explicitly stated in the contract, either verbally or in writing. These outline the specific obligations and rights of the parties. Implied terms, terms not specifically stated but included by law or assumed based on the nature of the agreement. For example, there may be an implied expectation that a professional, such as an architect, will carry out their duties with reasonable skill and care. Privity of contract. The concept of privity relates to who is bound by a contract. Only those who are parties to the contract have enforceable rights or obligations under it. This is particularly relevant for architects. For instance, if a builder fails to fulfill their obligations, the client, not the builder, may seek recourse against the architect, provided there is a separate agreement between the client and architect. Contract administration and the architect's role. Architects often serve as contract administrators on construction projects, which places them in a position of overseeing compliance with the terms of the contract. This involves certifying work, assessing claims, and ensuring the project progresses according to the contractual agreement. The architect's duties can vary significantly depending on the terms of the contract, and they may be described as a superintendent or contract administrator. It is important that architects recognize their dual role, acting both as the client's agent in some circumstances and as an independent certifier in others. Termination, repudiation, and damages. Contracts can end in several ways. Fulfillment, completion of all contractual obligations by both parties. Mutual agreement, both parties agree to terminate the contract. Termination under the contract. The contract itself may provide conditions that allow termination, such as insolvency or breach of an essential term. Breach of contract. A party breaches an important term, giving the other party the right to terminate. Repudiation occurs when a party demonstrates an unwillingness or inability to fulfill their contractual obligations, which may entitle the other party to terminate the contract if the breach is serious enough. Damages are intended to compensate the innocent party for any losses incurred due to a breach of contract. In contract law, damages are compensatory, meaning they aim to restore the injured party to the position they would have been in had the contract been properly performed. Key takeaways for architects. Contracts are integral to defining the roles, responsibilities, and expectations of all parties involved in a project. As architects, understanding both express and implied terms, recognizing your contractual obligations, and knowing when to seek legal advice are vital skills for successful practice. Architects must carefully manage their dual responsibilities, acting as both an agent for the client and an independent administrator, to ensure all contractual provisions are implemented effectively.